person is advocating forcing priests and ministers to do anything like that. At least none that I'm aware of. If doing so, forcing a priest or a minister to officiate at a same-sex wedding against his or her will, would obviously violate the First Amendment. More to the point, however, the objections of religious persons to same-sex marriage extend beyond the altar, meaning religious people have objections to same-sex marriage that extend beyond the actual performance of the marriage ceremony itself. So that there are a host of real conflicts posed by the legalization of same-sex marriage that are far wider and far more subtle than this sort of distraction of clergy being forced to officiate at same-sex weddings. So generally speaking, there are two sources of threats to religious freedom that are out there. First, religious organizations or persons could face lawsuits under state laws that prohibit discrimination on the basis of sexual orientation, gender, or marital status. And this would also include suits based on laws that forbid places of, quote, public accommodation from discriminating in the provision of their services. And I'll give some examples of lawsuits like that to flesh out this kind of general topic. So the first area is private lawsuits under state anti-discrimination laws. The second is that religious organizations or persons could face government action barring them from a variety of public benefits. So barring them from government contracts, limiting their access to public facilities, revoking their professional licenses or accreditation, or stripping them of tax-exempt status. The premise of those government actions would be that the religious organization is not acting, quote, in the public good, or that it is acting contrary to public policy. And so it would be easy to see how the legalization of same-sex marriage would give weight to government policies like that. It would be easier for the government to say, well, you're acting against public policy because, after all, public policy has been changed to show that same-sex marriage is a public good. So these are the two categories of where conflicts have already arisen and will intensify if same-sex marriage is legalized, and certainly if it's legalized without the appropriate protections written into the law. So some examples to help flesh out these, to make them more concrete and real. So first, from the area of private lawsuits. So suppose I run a religious school and I offer special housing to married couples. This is a familiar thing. I have married student housing. But on religious grounds, because of the nature of the school I run, I refuse to offer the same housing to a same-sex married couple. And so they sue me. Why do they sue me? They sue me for housing discrimination on the basis of marital status. Suppose I'm a religious person and I run a bed and breakfast. Sometimes I allow marriages to be performed on my premises, or sometimes I allow wedding receptions to be held on my premises. But I don't allow same-sex marriages or wedding receptions. Why? Because of my religious beliefs. I don't want my property to be used for something that I consider immoral. A same-sex couple sues me because I am a, quote, place of public accommodation, and I'm not supposed to discriminate on the basis of sexual orientation or marital status or what have you. Third, suppose I run a dating website. For religious reasons, I don't wish my service to be used to match up members of the same sex in relationships. So I'm sued for sexual orientation and marital status discrimination. So, what are some examples of government action that could be taken against a religious person or religious organization if they object to same-sex marriage? Suppose I'm a religious hospital and I refuse to provide my employees with spousal benefits for their same-sex legally married spouses. The state government decides I'm acting contrary to public policy and denies me a large grant. Suppose I'm a fraternal organization, and although I'm not a traditionally religious organization, I'm not affiliated with a church, say, but I have religious principles that animate my organization. And I openly oppose same-sex marriage, say, in my creed, or in some membership requirements or what have you, leadership requirements for my organization. A local government then denies me a lease, let's say that I've had for a long time, a government property, some government facility. Why? Because my beliefs are discriminatory and against public policy. Suppose I'm a religious person and I want to train to be a social worker. And so naturally I have to be licensed in my profession. But in order to be licensed, I'm told, let's say by a school or a licensing board or what have you, that I must affirm the morality of same-sex relationships, same-sex marriages. And I'm told, well, and I say, I can't do that. I can't be forced to affirm such a thing. And I'm told, find another profession. And I'm kicked out of a program. And let's say my supervisors of the program have sympathy for me because they don't like to see me kicked out of the program. But they say, well, we couldn't allow you to go through this process, given the beliefs that you have, because we're afraid of losing accreditation for our program. Later on, I'll give you some of the real-life cases that correspond to these difficult scenarios. So this list could go on and on and on. Let me close this part by making a couple of observations. This brief list of examples should convince everyone, I think, that the conflict between a regime that legalizes same-sex marriage and religious conscience is far, far broader than the sort of stereotypical question of whether the local priest, the local Catholic priest, is going to be forced to officiate a same-sex wedding. That, as I said, is a distraction from the real issue. Secondly, the threats here are most acute for organizations that don't fit the traditional profile of a church, traditionally religious organization, but instead are religiously oriented schools or hospitals or social service organizations such as an adoption agency or a dating service. Those organizations are exposed. More exposed, however, are the religious people who run businesses, who run the photography business or the florist business, or who have some kind of area that can be rented out for weddings, say. And again, we'll talk about the real cases soon. These people lack any protection in some cases for their ability to exercise their religious consciences in the face of a legalized same-sex marriage regime. And finally, and I'll turn it over to Lori, and this perhaps is the most disturbing thing of all, as you analyze these cases and say, of course, being a lawyer, many of you being lawyers, and maybe many of you fighting these kinds of cases, the first thing you think is, okay, well, suppose I have a client who's in one of these positions. Surely they have robust First Amendment protections. And the answer, of course, is no, they really don't. And it's not all clear how the law is going to protect people in these positions, absent strong legislative accommodations. And so having hopefully set the table, I will turn it over to Lori.
Thank you, Kyle, and I want to also thank everyone for being here today. I think this is a really interesting and obviously a very timely topic, and one that I'm glad to be able to, a discussion I'm glad to be able to be part of. If you look at the history of how this topic has developed, when the Massachusetts Supreme Judicial Court first legalized same-sex marriage in the Goodridge decision, religious liberty was not a major part of the discussion, at least at that time. I think many people were taken by surprise that this had happened and that same-sex marriage was now on the table, especially through a judicial decision. And so there was not, at least that I could see, there was not any sort of really organized discussion and chance to really think and talk carefully about what are the conflicts going to be between same-sex marriage and religious freedom. And shortly after the Goodridge decision, of course, Massachusetts Catholic, or Boston Catholic Charities had to stop providing adoption services in Massachusetts because they refused to provide or to place children, both for foster care and for adoption services, with legally married same-sex couples. And this religious liberty issue suddenly came to the forefront because we began to see and we began to realize that this was going to be a conflict and that it wasn't as simple as just allowing marriage and then letting the chips fall where they may, that this was actually going to impact this was going to impact religious social service providers, religious organizations, religious individuals in a variety of ways, because you are talking about one of the primary legal relationships in society. When you alter the definition of a primary legal relationship, then you're going to have a ripple effect of consequences that flow out from that. And so what we did at the Becket Fund was organize a conference of legal scholars to get together and start discussing this question, and to ask what would happen if same-sex marriage was legalized. How would that impact religious organizations and religious individuals? And what came out of that was a book we published in 2008 called Same-Sex Marriage and Religious Liberty: Emerging Conflicts. And where I think that book is very helpful and valuable is that it brings together people from across the religious and political spectrum. You have people who are not religious at all, people who are quite religious. More importantly, you have people who are quite strongly in favor of same-sex marriage and those who are not. And what they all agreed was that there would be a conflict, and that those conflicts would arise in many of the areas that Kyle has just discussed. Where they diverged was in what are we going to do about these conflicts. Tri Feldblum, who's now on the Equal Employment Opportunity Commission, made the argument in her article that religious liberty claims should fail, that same-sex marriage being more similar to race, as that's, I should say, the argument often being used, of course, as you're well aware, is that this is similar to racial discrimination, and so therefore the religious liberty claims need to be treated as lesser value claims in that situation, and that they should fail. Other scholars in the book offer different sorts of alternatives and different ways of thinking about this, such as looking at what we've done in the healthcare arena, where we have doctors and pharmacists who are able to maintain their religious freedom, who are able to maintain conscientious objector rights, and so are therefore not required to provide services that are contrary to and a violation of their faith. Since that book has been published, I think that this has become much more part of the national conversation surrounding same-sex marriage. And since we have seen more and more of these consequences begin to happen, more of these conflicts begin to arise, we've seen this become part of the discussion to where today you're seeing even bills that are passed in legislatures will be titled Religious Liberty and Civil Marriage Equality Act. I believe that was the title of the bill that was passed in DC. And so this has become a very big part of the conversation. Obviously, when Proposition 8 was passed in California, concerns over religious freedom were a big part of the conversation and the debate in that area. What the Becket Fund has done since that point has been to try and bring more attention to this issue. The Becket Fund does not take a position on same-sex marriage as such, on whether it's a good policy idea. That's outside of our purview. What we do take a position on is the need for legal protections if same-sex marriage is to be enacted, because we believe that is critically important. And so what our work is focused on is trying to educate the public and trying to educate the courts about the areas in which these conflicts may arise, and the need to act to protect religious freedom in case of those conflicts. And so what we have done is, in every state that has considered this judicially, we have filed amicus briefs to alert the courts to those issues. In many cases, the courts, especially those who have judicially mandated same-sex marriage, have not paid much attention to these issues. You often get just sort of a brief statement in a court opinion saying that, well, of course, priests and rabbis will not be forced to solemnize these marriages against their beliefs. And as Kyle so ably explained, that really is a false conflict. We'd have to go very, very far down a particular road before we got to that being a genuine threat. And we'd have to have a real erosion of our First Amendment freedoms and of our free exercise clause before we got to that being a genuine First Amendment threat. And so what we've seen is this, I would say, we've seen this become more and more part of the public conversation and the public consciousness, which I think is a positive development, but less so a part of, less so something that is judicially recognized, at least in cases, in decisions that have enacted same-sex marriage, or I should say created same-sex marriage judicially. That has been different in states where you have seen it done legislatively, which I'll get to in a minute. But that's been sort of the history of the Becket Fund's work on this issue and what we've done, and I think I will turn it back over to Kyle to talk a little bit about some of the specific cases that we're currently involved in and have been involved in.
Sure. Thanks, Lori. Fairly quickly, I'd like to highlight 3 cases in which the Beckett Fund is involved or has been recently involved that pose some of these issues. The first one is the most recent one, a case that is still in its very preliminary stages, and so it's not clear at this point how the religious liberty issues will develop or if they will at all. And yet on the face of it, the case presents a significant conflict between legalized same-sex marriage and the religious conscience rights of a hospital. And that is a case called Jane Roe versus St. Joseph's Medical Center, which is pending in federal district court in New York. In this case, a Catholic hospital, St. Joseph's Medical Center, refuses to extend marital benefits to the same-sex spouses of its employees. Now, they have been sued by a legally married lesbian couple in New York under ERISA. They're suing the hospital under ERISA, under the federal, under that long statute name that I can't remember what it means, ERISA. Notably, they're not suing under state anti-discrimination law. They're suing only under the federal law. And so the case may ultimately turn on whether ERISA gives them a claim for same-sex spousal discrimination and benefits. However, the plaintiffs in that case, and the case is styled as a class action, I might add, although we're doubtful that that is good, but we'll see. The plaintiffs are also raising the constitutionality of the Defense of Marriage Act in the complaint. It is also possible that the Religious Freedom Restoration Act may come into play in the case, since after all, the plaintiffs are claiming a right to sue under federal law, which of course raises the other very difficult question, which we'll talk about in a second, about whether RFRA applies to a lawsuit between private parties. So that's a case that, as we said, we're still at early phases. We're working with a good labor and employment firm in New York to represent the medical center, and we'll see how it develops. The second case is a case that has already gone to decision, at least on an appeal from a grant of summary judgment, and that's the Ward versus Polite case in the Sixth Circuit, which ADF handled and did very well at the Sixth Circuit, and then we filed an amicus brief in. That case presents this scenario, in which a Christian counseling student who was in a counseling program at a university, state university, was dismissed from the university program. Why? Because she refused to affirm the morality of same-sex relationships as part of the practical coursework that she was asked to do to complete the degree program. She had already completed most of the degree and had something like a 3.9 average and was doing very well. And then when she got to the so-called practicum, where she was supposed to counsel actual patients, and she was given a patient who was apparently having problems in a same-sex relationship, she asked for a referral. She asked that the patient be referred to someone else so that she wouldn't have to impose her values on the patient, and she also wouldn't have to violate her own religious faith by affirming the morality of the same-sex relationship. Well, the university kicked her out, to put too fine a point on it, and she sued under 1983, and she sued with claims under the Free Speech Clause and the Free Exercise Clause. The district court granted summary judgment to the university, and it went up to the Sixth Circuit, and the Sixth Circuit, an opinion by Judge Sutton first, and remanded it for trial. The reasoning of Judge Sutton is instructive and interesting, and also because Judge Sutton writes in the unusual way that he writes, it's also kind of fun to read, actually, if you want to read that opinion. What did it hold, though? So here we get into some of the difficulties I mentioned earlier. When you figure out, well, does a person like Ward, like I think her name is Julia Ward, does she have a First Amendment claim at all? Right? Somebody who's not familiar with First Amendment case law might say, well, of course she did. They're trying to force her to affirm something against her faith, and they just kicked her out of her degree program for not doing it. But as we all know, there's a case called Smith that says, well, if it's a neutral and generally applicable law, then you don't have a First Amendment claim. You don't have a free exercise claim for all intents and purposes. And so the question then became, well, is this a neutral and generally applicable law? And what the university said is, sure it is. We just don't allow our counseling students to refer